Hey, I'm Nancy Cavey. I'm a national ERISA and individual disability attorney, and I want to welcome you to this episode of Winning Isn't Easy. We're going to talk about the standard of review and why it matters in your ERISA disability claim. But before we get started, I have to give you a legal disclaimer. The Florida Bar Association tells me that I have to give this legal disclaimer. It's not legal advice. This whole podcast is just my thoughts and commentary. But am going to, in this process, give you a overview of what's happening in the disability insurance world, the games the carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Now, you have heard me mention the standard of review in many podcast episodes and YouTube videos, but it's time that we dedicate a whole episode to discuss what the standard of review is and why it's important. So the topics are going to be disability plan documents matter concerning the standard of review that courts will use to determine whether your benefits have been correctly denied or terminated. We're next going to talk about, can a disability carrier plan's failure to reference specific plan provisions change the standard of review? And I'm going to talk to you about the 11th Circuit's standard of review in a de novo case. And that's important because the alternative standard of review is something called de novo standard of review. And that's all important. And it's one of the first things I always want to know when I'm looking at a case and talking to a prospective client. Let's take a break before we get started. Welcome back to Winning Isn't Easy. Can a disability carrier or plan's failure to reference specific policy or plan provisions change the standard of review in an ERISA disability claim? Now, the ultimate question for federal courts in reviewing disability insurance claims or plans is to determine whether or not the carrier made the correct decision. But in the case of an arbitrary and capricious standard of review, the issue is not necessarily was it the right decision, but whether or not there was a reasonable basis for that decision. In other words, you could have made the wrong decision, but if it was a reasonable decision based on the facts of the case, then that wrong decision still stands. I think that's absolutely crazy. And it's obviously hard for people to understand this crazy standard of review. So what is a standard of review? When a court gets an ERISA disability case up on appeal, the issue, of course, is whether or not the decision to deny or terminate the benefits is one that should be overturned. And the court starts out by looking at the plan documents or policy to see whether or not we have what's called the de novo standard of review or we have the arbitrary and capricious standard of review. I, as a policyholder attorney, want the de novo standard of review. I want the court to be able to substitute their own judgment for that of the disability insurance company or plan, because obviously they've denied the claim. Now, the second, and the most common standard of review is called the arbitrary and capricious standard of review. I call it the get out of jail card review. It puts strict limits on what the policyholder or plan beneficiary has to prove to overturn an incorrect denial or termination of benefits, and makes it like a slippery slope. It's really hard to overcome an incorrect or wrong denial or termination of benefits based on the arbitrary and capricious standard of review. So what am I looking for? Well, I'm looking for the terms of the plan or the policy for specific language that says that the disability carrier has the discretion to make the decision and that type of language is sort of the key language that a court is going to be looking for, discretion to make the decision. Now, the failure to follow ERISA regulations can impact the standard of review, and I think that's important. And I'm going to have to give you some legal sites. But the failure to comply with Department of Labor's Claims Procedure Regulation 29 CFR Section 2560.503-1 will result in the claim being reviewed de novo, unless the plan or policy has established procedures in conformity with the regulations and can show that its failure to comply with the claims procedure regulations was both inadvertent and harmless. And the disability carrier plan has the burden of establishing that. Now, one of the ways that we go about arguing this is that Section 29 CFR, Section 2560503-1G1, little Roman numeral 2, requires that in the notification of any adverse benefit determination that the plan set forth in a manner calculated to be understood by the claimant reference to the specific plan provisions on which the determination is based. In English, that means one expects to see in the denial or termination letter a reference to the specific policy or plan that is being used to deny or terminate benefits. Now, another argument we make is based on Section 29 CFR 2560.503-1H3, little Roman numeral 2. Those two sections entitle you to a full and fair review of a claim and an adverse benefit determination. The plan is not on review to be giving deference to the initial adverse benefit determination, and it should be conducted by an appropriate fiduciary of the carrier or the plan who wasn't the person who made the initial adverse benefit determination. So we need a new person with a second set of fresh eyes looking at this. And the regulation also says, look, whoever's assigned to handling this appeal can't defer to the initial adverse benefit determination. And I will tell you that is exactly what happens. But the court's going to be looking for a detailed letter from the carrier or the plan reviewer summarizing the review and why they upheld the decision to deny or terminate benefits to begin with. And they're going to be looking for evidence of improper deference. Now, the fact that each reviewer independently sought similar documents, but not even the identical documents, is not evidence of improper deference. But you will see generally that the carrier on appeal is going to be addressing what evidence was reviewed initially and any new evidence and distinguishing that and explaining how they arrived at the decision to uphold the initial denial. The decision is going to be upheld by the court unless there is evidence that the decision to deny or terminate benefits is without reason and is unsupported by substantial evidence or is erroneous as a matter of law. Now, those are lots of loaded words, but the reality is that the court's review under the substantial evidence criteria is rather narrow, and the court can't go substituting its own judgment for that of the insurers if it was considering the issue independently. The definition of substantial evidence is evidence that a reasonable mind might accept as adequate to support the conclusion and requires more than a scintilla, but less than a preponderance of evidence. It's sort of like saying that breadcrumbs from a sandwich is enough evidence to support a denial. It's what I call the breadcrumb theory of substantial evidence. Now, this is a difficult evidentiary standard to meet because the disability carriers will cherry pick the medical evidence and they'll use liar for hire peer review doctors to not only justify the claims denial or termination, but they'll use these opinions to rebut what your physician, the treating physician, has had to say. So as a result, the disability carrier is going to hire a liar for hire medical provider, is going to fight about what your doctor has to say, and is then going to try to justify the claims denial or termination under this arbitrary and capricious standard of review, even if that's not necessarily the case, because that's where they're going to draw the line, plant their flag, and fight out what the standard of review is. And you can see that's going to make all the difference between whether the court upholds or overturns a wrongful decision to deny or terminate benefits. And we, as policyholder claimants attorneys, we take the same stand, but our hill is the de novo standard of review. Time for a break.